Good morning. My name's Mark Walmer. I'm a Pennsylvania criminal justice attorney for over 35 years. I run a company called Record Eraser, also known as Pennsylvania Pardon and Expungement Services, LLC. And I generate these podcasts to try to create content in order to help people figure out what's going on in the world of pardons and expungements. Today's October 18th, and we're filming at the Candy Factory in lovely Lancaster. Today's video, what I want to do is an update from the Governor's Board of Pardons with a recent meeting that they had, a merit review on October 13th. Then go into a bit of an overview of pardons and expungements and what the difference is between them. And then maybe follow up with some UJS record research and how to research your own record. And if we have enough time, maybe reading some of the typical stories I get through the day as I do this practice. So the Governor's Board had what's called a merit review meeting on October 13th. They actually reviewed 96 cases, I believe, for incarcerated people. And when you're incarcerated and you're trying to get a pardon or you're trying to get out of prison, that's called a commutation. And so at the merit review, the Governor's Board of Pardons reviewed 96 cases of incarcerated inmates whose applications they had already had investigated and reviewed. And at this vote, the vote was to determine whether or not the inmate would get a chance to do a public presentation. The way the process works, starting at the end, is what everybody needs is the expungement. Okay, and I'm not talking about incarcerated people. I'm talking about regular, everyday people with criminal convictions. What you want is the expungement, but you can't file the expungement on misdemeanor or felony convictions until they've been pardoned by the governor. That's a decree that the governor issues that gives you permission to file the expungement. In order to get to the governor, the board, which is 5 people, has to go through 2 processes. The first is a merit review to see if you have an application that's been investigated that's sufficiently convincing that at least 2 out of the 5 board members give you an invitation to come to a public presentation. Now, the public presentations, by the way, are by Zoom these days. They're not in person. They used to be, but now they're by Zoom, and they're about 5 to up to 15 minutes, but usually not, when the board gets to ask you questions and you get to explain why the crime occurred, what you've done with your life since then, and why you're a good candidate. So after that merit review, the board goes on to vote and determine if your case is recommended to the governor, and that's called a public vote. If you get a sufficient number of votes, then your case is forwarded to the governor for review. You need to get 3 out of the 5 board votes in order to have it sent to the governor. The governor is basically the 4th vote. So at this point, what you have is you've filed the application, which takes us a month or 2 to prepare. It's investigated by the board, and they reach out to do an investigative interview, which has probably taken a year or 2. Then it goes to the merit review to see if you're going to get enough votes to go to the public presentation. And then that goes to either a recommendation to the governor to issue a pardon, or your case is rejected, in which case the rules say you have to wait a year and then you can ask again. So that's sort of the process from beginning to end. Now, backing up into October 13th's merit review session, the board reviewed 96 cases that had been presented of incarcerated individuals. I don't know exactly how they voted on that because the incarcerated individuals are represented usually by other attorneys or by in-house parole officers. But then they got to the exciting part. As you'll recall, in September, Lieutenant Governor Fetterman and Governor Wolf allowed people to file their own marijuana misdemeanor do-it-yourself pardon applications online. And so from September 1st to September 30th, people were encouraged to go online if they had 2 kinds of marijuana cases. 1, possession of marijuana, small amount for personal use, or simple possession of marijuana. I'm not going to get into the details of the difference between the 2 statutes, but it was technically supposed to be one of those 2 statutes in order to do this. Not felony marijuana, not possessions of any other kinds of drugs, not possessions of paraphernalia. They were aiming at simple possession cases, marijuana only, and people were encouraged to go online and file their own applications. So that was at least hugely successful to the extent that 3,596 people went online and filed their own pardon my misdemeanor marijuana conviction case. So then, now we're at the merit review, October 13th, and the board is being asked, are you ready to vote on 3,600 cases? I'm just going to call it 3,600. And what the board decided to do was to take it under advisement because the window to the online applications had just closed September 30th. They're voting on October 13th. Their staff hasn't had time to get in there and to vet or investigate all of these marijuana cases to make sure they are only simple marijuana, that there are no other drugs involved, that there's no other disqualifiers, that it's not a felony. Because believe me, people will go online and they will just, file the application even though they might, I don't know. Anyway, with 3,600 cases under review, what they did was take those 3,600 cases under advisement to give their staff more time to go through and investigate. I believe they're trying to move as quickly as possible. I know that they have created the next board dates to meet are December 13th, 14th, 15th, and 16th. So 4 days. Sounds like they want to review a lot of cases. That's what I think is coming around the corner. So that's what the merit review hearing was all about, and that's how it went. And that's the update from the Board of Pardons. So now I want to move into pardons and expungements. What's the difference between them? I joke with a lot of people about how I'm basically a two-trick pony and how I keep saying the same thing over and over again, but it is confusing and it is a legal process and people do need to hear stuff over and over again, so I'm going to pretend that this is meaningful content and people want to hear it. But I'm going to do a really quick review of the expungement statute and then the pardon process. So expungement is a petition that's filed in the county of conviction that a common pleas judge signs that orders the Pennsylvania State Police, the arresting agency, and other agencies to expunge or clear a criminal record. And so the expungement statute is a statute written under 18 Purdon's 9122, if you want the legalese for the statute. That's the statute, and it tells you exactly what can be expunged. And so there are very small crimes, non-convictions, and things that have been pardoned by the governor. That's basically what can be expunged. Specifically, but quickly, juvenile records. Basically, if you've been over the age of 21, you've been out of trouble for 5 years, and it's not one of the nasty 9 felony crimes, we can file for a juvenile expungement in the county of conviction to clear an old juvenile record that might be following you around, because certain juvenile felonies can be reported by the Pennsylvania State Police to the FBI. They come up in clearances, and even though they're juvenile cases, they keep showing up. That could be a felony delivery of marijuana or some other relatively low-level offense that might be 5 or 10 years old, but written under the juvenile statute. We can file a petition. The district attorney either consents and then we get an expungement, or he objects and then we have a hearing. And I'll go into a separate video at some time about what's called a Wexler hearing, when the district attorney and the judge actually want to have a hearing to explore the merits of a requested expungement. Summary offenses, like somebody that picks up a retail theft, a summary offense, it's not a misdemeanor, it's not a felony, it's a summary offense. After 5 years of law-abiding conduct, that can be expunged in the county of conviction. It's pretty much a no-brainer. Multiple summaries gets into a different kind of evaluation, but that's all I'll say about that for now. Also, if you're a college kid or another kid, sometimes young people go out and they drink and then they get caught. If you have an underage consumption charge, that can be expunged by petition once you reach the age of 21. That is done in the county of conviction. It's pretty much a no-brainer. If the police bring charges and they're either null prost withdrawn or dismissed, in other words, there's nothing on that docket that you have been convicted of, an expungement petition will remove that. Now keep in mind a little bit of language here. A docket is a number, either a magisterial district docket number or a common pleas docket number, that contains numerous criminal charges on it. Might just have one charge, count 1, might have counts 1 through 3, 4 through 6. I've seen criminal cases with hundreds of counts within a single criminal docket. So if we're talking about a charge that has been withdrawn, dismissed, or null prost, I'm talking about there's nothing left on the docket that shows a conviction of guilt. If there's anything that shows a conviction of guilt, it's a different analysis. And maybe sometime I'll do a video about redaction petitions and what they accomplish. Also, the Commonwealth is under a certain requirement to record the disposition or the result of a criminal allegation. And so if you have been charged with a crime and for some reason the computer or the court system or the docket entries don't show a disposition and it's been more than a year and a half, we can file a petition to expunge that, because you shouldn't just have an allegation hanging around on your record that never followed through and received any kind of guilt indication or conviction. So that's a subsector. One of the nice things here, I'm going to switch into what if you have a misdemeanor or a felony conviction. Well, in all cases, except if you're over 70 years old, in all cases of people under 70, to clear that record, you need a pardon from the Governor's Board of Pardons and the Governor of Pennsylvania. However, the final thing that can be expunged under the expungement statute without the pardon process are misdemeanor and felony convictions if somebody has been off of parole or supervision for 10 years. In other words, they've been off supervision or parole since they turned 60, or even easily 10, 20, 30 years before that. They are eligible to have their case filed directly for an expungement without the necessity of a pardon application. Expungements take about a month to prepare. Once they're filed, the court reviews them for a month or two. Once the court order issues, the state police take a month to 3 to actually clear the criminal record. So basically a 3 to 6 month process is what the expungements are for. Pardons are for every misdemeanor and felony conviction. As you know, it takes a month or 2 to get the pardon application together by requesting all the court documents and then filing the pardon application with the candidate's explanation for why the crimes occurred, what they've done with their life since then, and how the record's holding them back, which is also why they're a good candidate. Once we get it filed, it takes the board up to 2 years to review them. Currently, they're taking about 24 months. If it is a marijuana-only related case, included marijuana-related paraphernalia, including possessions, simple misdemeanor marijuana cases, they can be expedited. And so the board would review them in as little as a year instead of the normal 2 years. Anything like a burglary, receiving stolen property, theft, etc., they need to be reviewed by the board, who's probably going to take up to 2 years, and then move into that process where it's investigated, they do a merit review, and then they do a public vote. So that's the pardon process. Takes a couple of years. Oh, by the way, I also wanted to mention those 3,600 pardons that hopefully are going to be issued by Governor Wolf for simple misdemeanor marijuana cases. Every one of them needs an expungement in the county of conviction. And what that means is just because the governor has issued a pardon, that gives you permission to file an expungement. I don't believe, since the expungement statute was a legislative creation that passed into law, Governor Wolf doesn't have any ability to say, oh, by the way, these pardon cases are automatically expunged. And so he will give the pardon or the permission to file the expungement, but every one of those cases is going to need an expungement in the county of conviction. And as I've said before, that's about a 3 to 6 month thing to a clear record. I always get questions about how to research the UJS portal. I've been researching it so long, it's pretty much a no-brainer to me. But Finding the records is one thing, and then researching the records is another, and then understanding them and evaluating them is something yet again. So I assume everybody knows this, but we're going to do a short tutorial on how to find, research, and review records from the UJS portal. So you find the UJS portal by just Googling UJS portal, period, Pennsylvania's UJS portal.pacourts.us will show up. Hopefully I'm sharing my screen now. And you want to go to case information, case search, and it'll call up a screen. And this is where you can search by different things. Now, these are the things you can search for. If you're searching, usually most people are going to search by name. There's other times when if you have the CP docket or the OTN, you might search for those, usually secondary research, but we're going to search by name. Now I'm going to search for the name of a famous person. This is a former Attorney General of Pennsylvania that got into a little trouble. And so what I want you to notice about this is the first screen that comes up. And you have 13, 14 columns going across the top, okay? And these are all records for Kathleen Kane. If you look over on the left column, you're going to see that there are cases that start with MJ and cases that start with CP. MJ is magisterial justice. They have their own docket numbers. And when a case goes from the magisterial district court to the common pleas court, they get a CP number. So the first number is the magisterial number or the CP number. The second number is the jurisdiction in which the charges were filed. The third set of letters, criminal, designates the CR as a criminal case, and then the actual docket number. Column 2 is what level it's at. Column 3 is the case caption. Column 4 is whether it's open or closed, the filing date. Primary participant is in that column. Now notice here at the date of birth, these dates of birth don't match. And so I'm picking up records for a Kathleen Kane that are not the Kathleen Kane that I was thinking about. And so now's the time to put in an actual date of birth to restrict the records to something more pertinent. So now here are the records of a Kathleen Kane. We can see one record from Lackawanna and 3 records, 3 from Montgomery and 2 from Lackawanna. One very, very helpful column here is the OTN. OTN is offense tracking number. And if you look down through here, look at case number 2 and case number 3. I told you how you get a case at the magisterial district level that then goes to the common pleas level, and that's why magisterial number 381 of 2015 and CP 8423 of 2015 are both tied to the same docket number. So that's one case that went from one level to the next. Is there another one of those? Well, yes, there is. Look at 414 up top here and 414 at the bottom. It's a magisterial record claim or a magisterial record that then transitioned to the common pleas record. So I'm going to open up, first of all, I'm jumping to the rightmost column where the Temple of Justice is there. I'm going to open it up. Now this is a summary. The summary is just going to show the name, a summary of the case. It's not all the information in the docket. It's just a summary. So number 1 here, here's a 22 case from Lackawanna, a DUI. That's curious, and I'm going to go back into that later, but it is not disposed of. I'm just interested in guilty pleas and dispositions. So in 2015, there was a conviction for felony 3 perjury. The sentence was 5 to 12 months, followed by 3 years of probation. And so that's the sentence and the disposition. Here's another docket number. See, whenever the CP docket changes, that means a new case. Probably sentenced at the same time. Very similar plea agreement for 5 to 11 plus 3. And so that takes care of those dockets 9032 and what was it? 6380-2. So that's why this is helpful. This is also where null pros, dismissed, withdrawn would show up. Not that it matters. If there's a guilty verdict, a guilty plea, a plea of guilt to any misdemeanor or felony, we know it's going to need a pardon. But on this case, I want to go back and I want to jump into this DUI from 2022. And I'm actually going to take a look at the docket. So the docket has more information. It has every docket entry that the magisterial courts or the clerk of courts have entered into the computer as the result of a case. So here's the 2022 charge. It shows there was a preliminary hearing April 21st. Actually, the preliminary hearing was rescheduled numerous times until October 4th. And it's a case of DUI that was sent to the Court of Common Pleas level, which is itself interesting because if we go back here to the CP, or actually the summary on the case search, that's docket 041-4. We do not have a, yeah, there it is. Okay, so we did the DUI. Something interesting I wanted you guys to see about looking at the actual docket on the 2015 charge is that there are additional docket entries. When you go into a docket like this one, it's numerous pages. In fact, this is going to be very long. This is every paper that was filed. This is a list of motions to revoke and increase bail. This is everything that happened in a case. And I wanted to see if there's any listings from 2022, and they do start appearing here. So here we see that there was an order scheduling a Gagnon hearing May 10th, 1922. If you recall from the DUI charge, it was right before that. A Gagnon 1 or a Gagnon 2 hearing is basically a parole or probation violation hearing. It's called a PV. It means while you were on supervision for 6239 of 2015, you got a new offense. And if you get a new offense during your period of supervision, then they can bring you back on both of the underlying 2015 charges, and they can resentence you as if you had never taken a plea agreement or a deal. So that's what a PV is, and that's what these docket entries refer to. It looks like July 28th, 2022, it was transferred to the other docket. I don't know if she was sentenced yet or not. She has paid off all of her fines and costs, but that's the level of detail that is in the docket searches that you get into in this case. So I think that covers, we should do something else too here. Switch from criminal to non-traffic. We always search criminal and non-traffic. The reason why is because non-traffic cases will dig out those pesky summary offenses like retail theft or disorderly conduct or public drunkenness or things of that sort. And she does not have any of those. And so I also wanted to just get into something else here and say, in terms of when you search, usually I search from the least restrictive conditions forward. And I want to show you what I mean by that. The system makes a lot of mistakes. They could easily have spelled Kathleen with a C instead of K, or Kane with a C instead of an whatever. I start by searching very, very broadly. And so here you can see the most things that can possibly show up. And this is a very unusual case, so it's really not a good explanation of this. But if I search for a K-A-T-H Smith, we're going to find literally hundreds of records that show up. And so what you do once you know a lot of records are showing up, this is when you either want to put in a date of birth or start spelling the name a little differently and try to home in on the specific record. So if you search too specifically, you might not find your record because of either a name change or a typo or something like that. So start with the very, very simplest spelling of your case and no details at all to pull in a very broad search, and then start refining it and limiting it down until you've found the records you need. By the way, if you find a record and you send it to mark@recorderacer.net, I'll be glad to review it and tell you what can be cleared and when. And that's what we do at recorderacer.net. Thank you. Boy, that's good coffee. One section I wanted to get to was just reading some of the stories that I run, me and my staff run into every day are the requests we get from people that have criminal records. Now remember, the Commonwealth has been giving out criminal convictions for decades, literally decades, and across all the 67 counties and all the different police departments, they have been giving out hundreds of thousands or millions of convictions every year. And so these convictions tend to be debilitating. They raise obstacles to getting a job, completing a job interview, getting housing, getting educated, or even qualifying for a mortgage or a loan. These things just go on to be researched, used against you, especially as we came through COVID, Corona, and the economic slowdown. Employers really are not taking a second look at somebody when they have other candidates that are just waiting to jump in and take the position. So anyway, another caveat that I want to make clear is that I'm a lawyer and my clients are protected by confidentiality, and even people that send me an email or fill out the form on recorderacer.net and I talk to them by phone, or I shoot them an email, or I research their record and send it to them for review, nobody's individual identifying information would ever be used in any of these content creation or blog posts or anything like that. The candidate, the applicant, is entitled to legal advice that is privileged and isn't going to go anywhere. So if I read a generic story about a situation, it's because I exclude any kind of personally identifying information, and I've identified it as being very similar and generic to literally thousands or tens of thousands of other situations that I run into. And so, having said that, here was an email from somebody. I pled guilty to making false statements. The online record said it was fraud to obtain food stamps. This is in 2011. I can no longer work as an LPN. I want to go to nursing school, but I can't start my clinicals until the record's cleared. So that's incredible. That's the kind of thing I get. I would review that in an instant. I would actually research the record and send it to this person. My personal takeaway is nonviolent offense. Financial offense probably happened during a time of financial necessity when you're trying to feed yourself and your family and pay rent, meaning also nonviolent. 11 years ago today, 2011, if the review process is 2 years, it's going to be 13-year-old nonviolent economic offense. I think you're a good candidate to file for a pardon. And while you can't speed the process up, it's still going to take a year or two to review. I think that case is going to get the votes it needs to move forward. This is another interesting one. I'll start with, back in 2014, I was an opioid addict as a result of recent back surgery. I took some pills from a family member who was charged with theft and recklessly endangering. 3rd-degree misdemeanors. Got probation, been clean ever since. I want to see if I can get my record expunged. So a couple of things I noticed there, and I'll start at the end as I frequently do. The record's not going to be expunged until it's pardoned by the governor, number one. So number two, we need a pardon. Number three, it's a crime that's based on opioid addiction that started with back surgery. And I don't know how many tens of thousands or hundreds of thousands of people got into car accidents or got hurt at work that went in for back surgery or some other kind of surgery, and they were prescribed strong medication and they became addicted to pain pills. And they continued to use, and then it's not unusual that their medical provider would sort of cut them off all at once, and the next thing you know, these regular people are figuring out where to cop pain pills. Sometimes the pain pills turns into methadone or turns into heroin or something else. It's absolutely heartbreaking, but it is not an untypical story. I think the pardon board's takeaway is going to be, how long were you in active addiction? How many years were you using? What was the extent or the magnitude of your use? How did you get clean? How long have you been clean? And what is your support network? The pardon board always wants to make sure, in the cases of addiction, that you have a strong support network and that there is virtually no chance of you relapsing and creating another crime after they excuse the first one. So the takeaways are, it's a very sympathetic story, and it's not an unusual story, and the pardon board reviews thousands of these. The solution, I believe, is going to be, what have you done with your life since then, and why are you a good candidate, including how long have you been clean, and how are you maintaining your strong support to prevent relapse. I don't know how many cases start out. I'm in my 30s. When I was 19, I had a boyfriend that was involved in a robbery, and the boyfriend and the girlfriend wants to be loyal. She frequently becomes an accomplice. So we know a couple of things already just after a sentence or two. She got charged with a conspiracy to commit a felony. Accomplice liability means you're charged with the same thing he is. He's committing robberies. You're in a close relationship. You don't disavow him. Oddly enough, the statute that allows you to deny responsibility for an accomplice not only requires you to disassociate yourself from the potential criminal, but you're actually required to make a report to the police. So you could actually distance yourself from somebody that you know is committing a crime, but if there's enough indications that you were with him during the planning or you knew that it was going down, even if you distanced yourself, the police will probably bring a charge because you did not go to the police and say, hey, this is going down, I don't want any part of it. So a woman in a close living relationship with a guy, frequently there's drug use. Frequently the guy will be dealing to maintain a lifestyle or at least pay bills. And when he gets raided by the police and they know he's in a living relationship with the woman, even if the woman is just turning a blind eye to what's going on, he's in the household. And then they search and then they find the drugs in the household. They get his statement. They frequently turn the woman or try to get her to testify against the man and threaten her with jail time or taking her children away. They threaten the same thing against the man, and then they try to just get convictions out of it. In this particular case, 2014, no, she was 19, and now she's 34. So 15-year-old, is that right? Yeah. 15-year-old charge, boyfriend related, nothing for 19 years. Even though it's a felony and it's a drug felony, if she's done a good job with her life, I think she's a good candidate. I think she'll get the votes she needs from the pardon board, but she's got to get that filed. Something I always like to mention at any point is that my whole participation in this process is, I have the website recorderacer.net, and anybody has a Pennsylvania conviction, okay, not Alabama, not Utah, not Texas, Pennsylvania conviction of any sort, if you fill out the form, first name, last name, date of birth, email, and phone number, it comes only to me and my crew. We research on the UJS portal. If we can't find it, we give you an option for getting a more official, more complete criminal history. Our job is to help you find the record. Once I look at it, I can tell you what can be cleared and when through the use of pardons and expungements. None of this costs anything, because what I do is, once I figure out what is needed to clear the record, I quote a fee for the pardon or the expungement based on the number of charges, possibly the county where the conviction is, etc. Charged with an F2 conspiracy to commit burglary and F2 burglary in 2013. Broke into a shed and stole music equipment. Come from a big hunting family. Trying to get my gun rights back. The reason I'm laughing is because burglary is always charged as a felony. There's basically 4 counts of burglary and 3 different gradings. You're going to get a quick version of that. Burglaries are either going to be felony 1s or felony 2s. All right, 2 classes. If you go into a person's house and their home, it's going to be a felony of the 1st degree, very serious burglary charge. In fact, I think if you go into a house and nobody's home, it could still be a felony 1 because the home is the castle. If you go into a business and there's nobody there, less privacy concerns, it's a felony of the 2nd degree. When I was a prosecutor and a defense attorney, when I was a prosecutor, I didn't get it, and I'd have to talk to the police about it. But when I'm a defense attorney, I was just always going at the district attorney. This guy went into a shed on a lawn that might have an occupied house, but he took music equipment. Isn't this more like a business burglary where there's no one's there? I understand that it's a house and there's a lawn and a shed. But anyway, these are charged as felonies of the 2nd degree with potential maximum jail sentences of 10 years or more. My personal thought is I see the same burglaries, felony 2s, when a drunk kid goes into a distributor and takes a case of beer, or goes into one of my favorites to dislike was when you go into a high school tool shed because you're a teenage kid and you go in and toss the jerseys and the first plates around and stuff like that. I agree, it's criminal behavior. It's definitely criminal mischief. It's definitely criminal trespass. But the felony 2 nature of criminal burglaries, I think, is a little bit of overkill. So anyway, 2013, 9 years ago, felony, which raises the stakes. The more serious the crime, the more time the board wants to see go by before you apply for a pardon. But 2013, 2-year review process, that thing's going to be 11 years old. Nonviolent offense, when he was, how old? I'm betting you he was 20 or something. And then commits this. It's followed him around. It's dogged him for 10 years. I think we can help put together a sympathetic story about why the crime occurred and what he's done with his life since then. There are a ton of people in Pennsylvania that are hunters and fishermen. Not that you can't fish if you have a criminal conviction, but they're hunters and they either want to put meat on the table or they want to go to their hunting camp. And it's a tradition and a ritual. And taking people's firearm rights away from them as a result of old conviction is just one of the lingering side effects that's just not right. So, and also to answer a side question that I can hear coming up, if you get the pardon and then you get the expungement and that record is clear, then your Second Amendment rights come back to you as if they were never gone. The Second Amendment rights leave because you pick up a disqualifying conviction, whether it's a misdemeanor drug offense or whether it's any kind of felony. Those convictions disable your Second Amendment rights until they're removed. When they're removed through a pardon and an expungement, your Second Amendment rights come back without hindrance to purchase, to possess, to carry, as long as there's no other disability from another state or another incident, your rights come back. So those are the things I wanted to cover today, October 18th, 2022, and leaves are turning, and we're sitting here with the production crew, which is just Sam and Jeff, and I'm going to take another sip of some great coffee, and then we'll see what they want to do about any follow-up or what do they call B-roll or something.
Should we be sponsored by Byler's?
Nope. Just like their coffee and their donuts. At some point, I'm going to look, it's a great Lancaster County company, and you don't need to be sponsored for every piece of content when you have good donuts and good coffee, so it's just a gimme.